So you wanna go to war with me? You're talking like you think you're royalty. You think that I'm afraid, but I don't break. I heard you question my stability. You think I'll fall just like a guillotine, but I am here to stay. Won't look away. The storm is coming.
Yeehaw!
No, you can't control. Feel it in my bones. I'm coming for the, coming for the.
All right, guys. How's everybody doing tonight? Let me check my sound system here. All right. Woo! Just got back from watching Sisu, the Finnish gentleman that struck gold and then got pursued by the Nazis. Today was the first day that you could go see that film. I do highly recommend it. It was a very enjoyable film, kind of like a Quentin Tarantino type vibe to it. In this live stream today, I'm going to start off just by going through the stipulation and agreement of settlement and the, what is this other document? The notice of pendency of stockholder class action and proposed settlement. So how they're going to notify you. And it's mostly going to be the second document. I'm going to read through a bunch of stuff. I'm not going to be paying a whole bunch of attention to the comments because I'm probably going to clip this part and then make it a standalone video for whoever doesn't want to watch a 2-hour live stream. And then I'm going to hang out with you guys and we'll have some fun and go through whatever questions you have. I don't care which side of the aisle you come to for this live stream. This is just me presenting information, reading from the documents for those of you who don't have access to them. And we can get into the more of the opinion stuff, Q&A, speculation, things like that after we go through the document. So I hope that sounds agreeable. While I have everybody here, I wanted to say a few words just to clarify. I feel like I say this fairly often, but since we might have some new folks here and there's a lot of people that, I don't know, what's the word? Lie, make up information out there. First of all, I'm not an attorney. Let's get that straight. I'm reading a document to you. I'm not paid by anybody. I volunteer my time to bring you guys information because there is a bunch of financially uneducated folks putting out clickbait and misinformation, and it really irritates me. And I think that at least one person that is covering the stocks that you like ought to have the sanity to provide you real information from company filings, for example, from financial statements. And I have the ability to interpret those and explain them to you in a common sense financial way. And so sometimes my content might be different than what you're used to hearing. This is not all speculation and hopium, unicorns and rainbows, but I am in AMC and APE just like you guys. And I have been for 2 years. And it is really irritating when people say otherwise. So hopefully that is all clear. The other reason that I focus on the fundamentals and the financials, I hear people say all the time, you know, if I can't get my way with a short squeeze, I want the company to go bankrupt. Let them run out of cash. And I feel like I have an obligation to be an advocate for the other people. You know, you're in a minority if you want this company to go bankrupt if you can't get your way. And I have an obligation to be a voice for everybody. I understand your desire for a short squeeze. I understand it and I get it. I'd love one too. But not everybody is willing to see the company go bankrupt if they can't get their way. That's a little bit selfish, and it means that viewpoint is ensuring that all of us lose. And I will continue to be the voice of everybody. So you're welcome here, whichever side you're on, but just keep it respectful. I don't engage with trolls, but I think it's probably fair to say in most states, stalking, harassment, reputational harm, libel, all of that is illegal. And I have been keeping receipts now for well over a year. And at a time of my choosing, don't be surprised if you get a knock on the door. Let's just try and be good to each other and realize we're all on the same team here. Because I don't appreciate people making up shit about me, and don't think that it's not being cataloged. All right, let's go into some documents. The first one that we're going to look at is the stipulation and agreement here. A lot of this is just a recap of everything that we already know, how we got here. So the thing that I really wanted to highlight in this document, and I already have it highlighted, I've read through all of these twice, is some questions that you guys had about how are they going to notify us. This was really the new information in this document. And we'll get into what the settlement is and how to write letters. We'll get into that in the next document. In this particular document, they did propose, and I don't think that the judge has signed off on all these yet. These were just submitted today, so I expect that she will. But there still could be some changes, okay? But this is what we have. AMC shall provide notice by filing an 8K. They shall post a copy of the stipulation notice on AMC's website all the way through the effective date or when the settlement is complete. And they shall transmit the summary notice over PR Newswire and post a notice on AMC's Twitter account. So it looks like the issue that we were wondering about, spending $3 million mailing it, I didn't see that in here. Didn't see that in here. Let me pop out this chat here. I think that as far as this document, that was the only thing that I highlighted. Everything else it was already talked about in previous live streams. So let's go over this one, which I do have a lot highlighted in. This is goes over a lot more detail about how we got here to the settlement and who is a record holder and who's going to get paid and what are you going to get paid. You are a record holder for this class action if between August 3rd, 2022 and the time of the conversion and the reverse split, you held AMC common stock. So if you're holding on the day, and I expect that right after the settlement is signed off by the judge at the end of June, AMC will probably already have pre-filed the paperwork with Secretary of State of Delaware and NYSE to affect the reverse split and the conversion. So you are a record holder as long as you're holding it the day before that paperwork's filed. You'll get the settlement or the payout. It does not apply to APE. It's for AMC shares only. It says, when is the payout going to happen? It just says it should appear promptly thereafter. It doesn't say like a day, 2 days. I don't have that information. They just say promptly. That's the payout is in this settlement 1 share for every 7.5 shares of AMC that you have after the reverse split. If you would like to object, you may write a letter to the lead counsel. So a lot of people were sending letters to the court. We'll go through the instructions in just a minute of how to write a letter or an email. But remember, you're not going to be mailing it to the court. You're going to be mailing it to the plaintiff's attorney. It doesn't say in here in this document the date. We'll probably get an updated one tomorrow once the judge signs off. But I think it was like 15 days before the actual hearing. Don't hold me to that. I'll publish the date when I see an actual date in here. Probably around mid-June. You know, if you want to object, you want to write a letter, it'd be best to do it early. That way you don't have to worry about what the date is, what's the due date. The court has not yet decided on whether to approve the settlement. So the settlement decision will be finalized on June 29th or 30th. So this is a proposal. Everybody has time to object or write letters of support. And then all of that information will be compiled, looked at by the judge, and the decision will happen at the end of June. And it even also could be amended by the judge, right? She might say 1 for 7.5 is not good enough. I mean, that's potentially could happen. I mean, just for example, she could say 1 for 5. So this is this is the proposal. It is not yet decided if it's approved yet. What's happened in the past 2 months? Plaintiffs reviewed 59,000 pages of documents provided by AMC, and additional 3,200 pages of documents provided by third parties. And the plaintiffs responded to 26 document requests from AMC. This paperwork, by the way, the settlement is submitted to the court by Allegheny's attorney. So when it sounds like it's all being written by the plaintiffs, it was written by the plaintiffs. So they're saying what they reviewed and what they provided AMC. AMC gave them almost 60,000 pages of documents. Like I just said, if the settlement is approved, for every 7.5 shares of common stock AMC that you have after the reverse split, you will get 1 share of AMC, and fractional shares will be paid out in cash. I highlighted this because I thought it was interesting. Lead counsel, the plaintiff's counsel, expects that the price of shares of common will trade based on numerous factors, including the anticipated likelihood that AMC will be in a better position to raise capital to finance its business in the future as a result of the conversion, which is something I've been pounding the table on. Someone asked me earlier today, like, well, isn't it good news if the settlement gets delayed? And, you know, everybody has their own version of good news, bad news. There's today's good news, and I like today's good news, watching prices go up. But there's also good news, bad news 3, 4, 5, 6 months from now. If the settlement was delayed or AMC had no ability to raise cash, could be really bad news for the company. Could be. A lot will depend on what we find out May 5th about AMC's cash position and how well Q2 goes, and then what happens in Q3. But if the settlement goes through at the end of June, all of my concerns that I've been talking about regarding cash should be off the table. You won't hear me talk about them anymore. Everybody's like, thank God, we're sick of you talking about that shit. I get it. Settlement class time, as we said earlier, that is, how do you know if you're in the class? If you hold AMC on the business day prior to conversion, you're in the class. Only record holders of the common stock, AMC, are in the class and entitled to a payment. No ape. What are the parties' reasons for settlement? Now, the plaintiffs say they brought their claims in good faith, and, you know, I'm sure they thought and continue to think that they had good reason to bring their claims, as they say. They even say that. We continue to believe their claims have merit, but based upon plaintiffs and lead counsel's investigation and considering the risks of continued litigation, like draining AMC's cash, or maybe they have some debt thing coming up, because we keep on hearing about August. I couldn't find anything specific to August on the debt, but there are risks of continued litigation. And of course, both parties have costs. In light of that, they have determined that the settlement is fair, reasonable, adequate, and in the best interest of AMC common stockholders. The part that I highlighted down here is the plaintiffs say that even if they could show a likelihood of success on the merits of their claims for injunctive relief and irreparable harm with respect to the filing of the certificate of amendment, that's to do the reverse split and conversion, lead counsel determined that it was unlikely that the court would invalidate APE. And that's something that I've been telling you guys for a couple months. It would be very unlikely that the court's just going to say APE is illegal. And they go on to say more about that and the reasons why they're saying this. And they put it in bold and italics, and, you know, in case there's any doubt. In assessing any balancing of the equities, the court would consider the harm to people who bought APE on good faith. So anyone that bought APE, not just the people that were handed it. If you were just not even aware of what's going on and you bought APE and then the court invalidated it, now that person has harm. And so the court has to consider all of that. And the plaintiffs kind of said, yeah, I mean, we get it. It's probably, you know, considering all of that, it's probably not likely that the judge is going to just rule APE illegal. And then they go into the legal argument about it, though, this Section 242b2 of Delaware General Corporate Law. And this was where I was saying in my reading of that, and again, I'm not an attorney, I did not see any illegality on AMC's part. If I did see it, I 100% would tell you. I'm not here to lie to people every day. If I see bullshit, I will call out bullshit. But I'm going to highlight what the plaintiff said here. A recent decision from the Delaware court says that Section 242b requires any special rights for a class of stock to be expressly granted in a corporation's certificate of incorporation. And there's a not in here, so I just want to read this twice. AMC's certificate of incorporation did not grant voting rights solely and exclusively to holders of common stock. What that means is you can go read back from 2013, the original articles of incorporation, and I have. The board has the power to grant rights, including voting rights, to any class of share it wants. That's in the original articles of incorporation. And as long as that was in there, they can pretty much do whatever the heck they want. So it was not illegal from that standpoint. Moreover, in green here, AMC's certificate of incorporation expressly grants the board the ability to issue preferred shares with voting rights. Again, stuff we've talked about here many times. And